from NDSP. So today I've got Margaret Irvine from Legal Aid WA joining us just to answer some unanswered questions from our National Support Coordinator Brunch, which we had on the 19th of May.
Hi, so my name is Margaret Irvine. I work for Legal Aid WA. I'm one of the solicitors dealing with the NDIS appeals team. We principally deal with external appeals. That's when a client has had internal review decision. They are not unhappy with the internal review decision and they want to progress the matter to the AAT. So that's principally what our team has funding for and how we help our clients at Legal Aid. So I understand we were going to talk today. There was some feedback for some additional questions from the conference last week and you wanted me to give some general information. So fire away with your questions.
Okay, well, I might take the first one if that's okay, Tanya.
Sure.
So we have a question, and the question, the way it's formed, I have recently had a client requesting an iPad Pro for just under $1,500. The physio had sent an email with a generic reasoning supporting the participant to purchase this item. I guess from your experience, what are the types of justifications that get items through or get things approved with the NDIS? I think that's been a really hot topic.
Yeah, as we spoke about at the conference last week, and we can't obviously speak about individual cases or individual matters. What the information we'll give today is just general information, but you know, the gold piece of information to everybody is evidence, evidence, evidence. We really have to be quite concise with the information that we provide, because that information is what the NDIS weighs upon heavily in any decision-making process. So when you decide that you're going to recommend a therapy or a device or any type of support that you think may benefit your client, the best thing you can do is, in some respects, put yourself in the position of the NDIA with no experience and knowledge of that client. How would you persuade that person? And the best way to persuade them is with evidence. Now, the evidence should not only be why this device is important, but also the benefits of the device, where you see the participant progressing with the assistance of that device. But equally important is to actually explain to the NDIA where the participant's likely to be without that support or without that device, or the detriment of not having that device. So not having the device and providing that evidence is as important as providing the evidence for why this is good, because the agency will look at it and they will say, well, okay, yep, this is going to improve somebody's life by an iPad Pro, but is there not any other items out there which could actually be equally as beneficial, or could this not be attained by using additional therapy or support workers, or why do we actually need this as a benefit? So you have to weigh up both sides and show both sides of the argument and be able to present your matter forward. And that's some of the evidence we find sometimes needs a little bit of improving with regards to clients who are putting matters forward to the NDIAs. They have these amazing clinicians who are a great team, a multidisciplinary team supporting, but they just don't always explain where everything is with the evidence. Does that help?
It does indeed, absolutely. Thank you. Tanya, did you want to ask the next question?
So the next question we've got here is, the main problem when dealing with the NDIS is the continuity of information obtained. What guidelines would you suggest to follow to ensure that we get a streamlined response?
That's an interesting question. It really just depends where they're getting the information from or where they're trying to get the response from. Obviously, there's a national call centre which processes all the information that goes to and from the agency. If you have a relationship, obviously, with local area coordinators, that can be extremely helpful as well, and it can be quite empowering for your clients. Some clients have high-level need supports. One of the examples they give in the price guide and the guidelines is someone who has uncontrolled seizures, who can have multiple seizures a day, and they fall under the complex needs. And what they can do is you can actually ask for a referral to the complex support needs team, which would give a tailored process, but that's specifically for clients who are of a very high level need and a high level support with associated risks. Perseverance, I say, would be another way of tackling it, and make sure that you keep an evidence trail. So any calls, any communications, ask for the interaction number, ask for names, and ask for, record the time in which you made that call. Because if the matter does progress to Administrative Appeals Tribunal, we will receive a huge document called the T documents, and that's all the evidence that the NDIA used to formulate their opinion, and that includes the interactions and the interaction records. So what can happen sometimes is they may miss an interaction, or for whatever reason we are not provided with that. But if we have a support coordinator who can turn around and say, look, on the 1st of July 2019, we may put a call in at 2:30, and this is interaction number, and this is roughly what we discussed in that call. We can actually go back and then do an FOI and say, well, look, you've not provided all the interactions, we're asking for full disclosure. So that's another thing that can be helpful as well, is really keep a record of all the contact you're making. It's very difficult because everybody's time poor and time sensitive, but it's, even if it's a diary that you have and it's a 2-second called NDIA today at 2:15, interaction number XYZ regarding client ABC, it's helpful.
Oh, that's great. Yeah.
That is fantastic advice. Thank you. All right. So the next question we have is the human element and interpretation of reasonable and necessary. I guess that has been a major issue from the LAC level to, individual participants, families, and support groups. I mean, even in plan management. So I guess because it is an obstacle, how do we overcome this? Well, what is your advice?
Look, it goes back to our very, very first conversation, and it's evidence. The human element, we're dealing with clients who are potentially vulnerable and complex, and we're not only assisting that client, but we're assisting the informal supports, the family, the friends, the relatives, the mums, the dads. Evidence that's persuasive, again, it's about having relative evidence. When you're talking about reasonable and necessary, the NDIA obviously has an obligation that they've got to make sure that the supports they provide are distributed fairly across all participants. So whilst there is a human element, that tends to be in the form of self-reported evidence, or we would refer to it as self-reported evidence, and that can take the form of statements of lived experience, and that can be a very powerful tool. What that tends to be is evidence provided either by the participant themselves through conversation or through maybe this informal supports. And just to explain, the way I tend to do it is a day in the life, which is a day in the life of the participant, where their needs are and how their needs and their impairment affects their everyday, and how the support that you're requesting can actually impact positively on their life. And again, how their life will be without that support. Again, it's really important to show the benefit and also the negative of it. That can be really, really persuasive evidence. But again, clinical reports, make sure that reporting's done really quite regularly. As support coordinators, it's such a valuable part of the multidisciplinary team, because you can keep on top of the clinicians, and it gets to that 10-month period, a year plan. And if you're able to start collating all that evidence now and saying, look, speech pathology, what do you think? Where are we up to? Where's the progress? Where are we having issues? What do you think we need going forward? And then you can compile all that evidence going forward. It makes it much easier for the NDIA to then be persuaded this evidence is the reason for the supports. Unfortunately, the human element, it's hard. It's very, very hard, I would imagine, sitting on the other side, and it's very easy to be critical and and turn around and say, well, why did they make that decision? But they obviously have to be guided by their process, and we're potentially dealing with NDIA and staff and personnel who may not have clinical background, clinical knowledge or experience. So it then becomes equally more important that you're able to persuade them effectively on why you need that support. So what the human element is valuable for self-reporting, but it also comes with an element of clinical reports and multidisciplinary reports as well. It has to be a nice balance and a nice flow.
Thank you. And Tanya, did you have a question?
We've just got one last question was, can you identify the landmark cases that have shaped the landscape for NDIS?
Certainly, I mean, the big cases would predominantly be McGarrigle, which was the case regarding transport funding. I've got my notes here. If I can get, I'll get you if I can find the case number for it. And so essentially, with McGarrigle looked at if a support is deemed to be reasonable and necessary, then that support should be funded in full. Now, that's very, very valuable when we're looking at supports and it comes to that bargaining end of review requests or unplanned plan reviews, in which, you know, you may ask for 400 hours of support working hours, and the NDIA may come back and say, look, we only deem it to be 100 hours as reasonable and necessary. But if you can actually provide that evidence to say why this should be provided in full, and it's a full support, or the most common one, and I'll use McGarrigle as the actual reference point, was transport, and Liam McGarrigle needed $15,000, it was, I think, a year for transport for him to get back and forward to from the home to his work, his study and various appointments. The NDIA agreed that it was a reasonable and necessary support, but they only agreed to partially fund it and said, we're giving you I think it was around about $10,000. And they deemed that was more than sufficient for funding. And the tribunal in the first decision came back and said, yeah, well, we agree with that decision. It's quite a high level of funding, and given that there's level caps with transport, level 1, level 2 and level 3, that was deemed to be a reasonable outcome, but the family pursued it and took it high level. And then the officiating decision came out that if the support is reasonable and necessary, it should be funded in full, it shouldn't be partially funded. And I think that's one that we have to be very, very aware of in the case law and moving forward. With AAT matters and NDIS matters, something to be mindful of is, whilst case law can be persuasive, it's different. AAT and administrative law matters are slightly different from criminal law cases, where they set precedents and the judgments tend to follow those precedents. We're looking at persuasive case law, and what I mean by that is, you know, there's a lot of outcomes that can happen where there's maybe 3 decisions. For instance, access to PTSD was a very recent one, and the first 3 decisions that came through for that were no, we're not granting access, and then the 4th case that came out was actually really very, very persuasive with the evidence and the particular situation of this client. And remember, it's very individualized when we're looking at this particular participant. And the outcome is that they recognised it as a permanent disability for access. So case law is helpful in the way that it can be persuasive, but it's not for setting precedents. So, you know, it can help you form your argument, or it can be good to reflect on, to think, well, what were the positive parts of that case law, and what was helpful, and again, similarly, what wasn't helpful, what actually went against the applicant in this matter. That helps you form your case, and that certainly helps us when we're dealing with matters. We've been quite fortunate in WA, touch Herrywood so far, that we haven't had a hearing yet. We've managed to settle most of our matters that we've dealt with in legal aid through case conferencing and conciliation. No doubt at some point that will change and a matter will proceed to hearing, but we've been really quite fortunate in WA from that position. I think a lot of that is we do a lot of groundwork at the entry level as well, to try and get as much evidence through, and I think we're quite frank and we're quite honest with our clients as well about reasonable expectations of what outcomes could be. But it's an ever-changing field, and you know, again, it relies on the evidence, and everything falls on the evidence in these matters. It's a very evidentiary based process.
Fantastic, thank you. Amazing information that you've provided, and certainly it's going to be very useful for our listeners. Tanya, did you have anything else to add?
No, I haven't. Thank you very much, Margaret, for joining us again.
Absolute pleasure.
And it's been an absolute pleasure. And please, if you could maybe email through some links to any resources or anything we can share with our listeners, that'd be greatly appreciated. So thank you.
My absolute pleasure, and I'll find the link for the McGarrigle case and send it through, because it's definitely a case that everybody should know and look about. It was such a big case for NDIS case law.
It's fantastic. Thank you.
Pleasure.